Good afternoon. I'm Ed Owen, the Director of Communications of HMCTS. Welcome to everyone that's joined this webinar to talk about video remand hearings. This is the first of a series of events which HMCTS will be doing to engage legal professionals and professional court users on a variety of reform topics. And we're most grateful for you taking the time to join us. I just want to quickly go through the format for the next hour so people are aware of how we will run this event, which is the first time we've done it by webinar, so there'll be maybe some rough edges, but I hope you'll excuse that, but hopefully it gives an opportunity for as many people as possible to engage on the important issues of reform. I'm soon going to introduce Kevin Sadler, the Deputy Chief Executive of HMCTS, to talk about wider reform and to give an introduction to that. And then we'll hand over to Julie Parkin to talk about the video remand hearings project. We'll then have some time for questions and answers. And if I can just say that you should see on your screen, if all is okay, you should see on the left-hand side of your screen a question box. And I would really encourage as many of you as possible to submit questions via that route. And please start asking questions at any time from now through the presentation and beyond, so that we will do our best to answer as many of those questions as possible at the end of the event after the presentation from Julie. For those that we do not have a chance to answer in the time of this webinar, we will post those answers in writing via the HMCTS website as soon as we can. Without further ado, I'm going to introduce Kevin Sadler, Deputy Chief Executive of HMCTS, to talk, give us an introduction of overall reform. Thanks, Kevin.
Thank you, Ed. I'm very pleased to be able to join you today at this online event, and today's part of a series of face-to-face and online events about our reform programme. They're designed to give legal professionals and professional court users the chance to learn about what we're doing, to ask questions and to engage in the shaping of future reforms. Following on from the first phase of roadshows that ended last May and drawing on the feedback we received, we've designed this and other events around particular issues. And we're also using remote technology as well as face-to-face events to ensure we engage as widely as possible. So today's session will be led by the project team for video remand hearings. So please do try to restrict your questions to that subject area. You will have the opportunity to ask questions about wider reform issues and hear from and question Susan Ackland-Hood and other senior colleagues at HMCTS in other events that are more jurisdictionally focused over the coming months. So I just want to say a bit about the context for today. As I hope you all know, our ambitious programme of court reform is well underway as we invest £1 billion in reforming the justice system. The transformation programme aims to bring new technology and modern ways of working to make all jurisdictions operate more smoothly and efficiently. We want to improve access to justice as well as reduce unnecessary costs. This will ultimately benefit all users of our courts and tribunals as well as those who work within them. We've got one of the best legal systems in the world, yet our systems and processes haven't always kept pace with the rapid technological developments in the world around us. It's crucial that we move with the times and make best use of new technologies to deliver swifter and more efficient justice. And we know we can make justice less confusing, easier to navigate, and better at responding to the needs of the public. We've made a great deal of progress on reform already, and many of the changes have come from very detailed and active collaboration with professionals, users, and members of the judiciary. We're determined to ensure that all those who work within the justice system, as well as those who care about it and are most affected by the reforms, are involved and engaged in the process of reform. So the video remand hearings pilot we're talking about today is an important part of the wider crime programme within Reform. This area of the Reform programme supports our ambition to provide smarter, more joined up and streamlined processes to deliver better criminal justice for all. We've already made some great developments online, but there's still more work to be done. The crime area of the Reform programme will support digital working throughout the criminal courts. It will enable all participants in the criminal justice system to work from the same information to reduce duplication of effort. It will introduce more consistent working practices. It will also allow us to deal differently with things that don't need to be in court. So during this online event, we'll tell you about our plans to develop a national video remand service. We expect to transform the way in which hearings for defendants held in custody are administered by moving hearings out of the physical courtroom and into a video space where it is right to do so. The project can simplify and streamline processes whilst providing flexibility for all parties to engage with the justice system without the need to appear physically in court. I do hope you find it useful, and please do submit questions to our expert panel leading the Video Remand Hearings project using the interactive platform throughout the session. Thank you.
Thank you, Kevin. I'm now going to hand over to Julie Parkin, who will be presenting on video remand hearings, and as I say, we will be answering questions following that presentation. So, Julie.
Thanks very much, Ed. Thank you, Kevin. So I'm Julie Parkin. I'm the Crime Service Manager with responsibility for the Video Remand Hearing Service project. And over the next sort of 20 minutes or so, I will be talking to you about, what it is that we have been doing, where we are now, and also with a bit about, how hopefully you will be able to get involved and be engaged with the next steps of where we're at. So, I suppose the starting point is, what is a video remand hearing? We view this as the first appearance before the court of defendants who've been refused police bail. And currently, obviously across all courts it varies, but some areas have live video links operating from police stations where the defendant can appear in court for that first hearing. Occasionally a defence representative may also join that hearing via video link, either because they're co-located with their client or because they might be in a different court at that time. And the other feature I think about current processes are that they're all local. They're locally developed processes, procedures and standards, and I think it would be fair to say that we've got inconsistency in approach nationally. So Kevin touched on what the future aspirations are for video remand hearings, and in brief, what we are looking to do is to make sure that we have technology that is capable of operating a fully video remand hearing, by which all parties, including the bench, could attend by video link. So we have that capability, technological capability, that we have a nationally consistent set of processes, procedures and standards that would be applied, and that the technological solutions that we are developing and looking to implement will design out current inefficiencies and delays in the process as they happen at the moment. So what are the potential benefits? Why even bother looking to do this? So we're particularly focused on how we can reduce the amount of time that defendants are held in custody without a judicial decision, particularly how many defendants are held overnight, and to reduce unnecessary journeys, either of defendants or of other parties who would be attending the hearing. It's also an opportunity, of course, to look at improving the processes around those who are appearing on video from the police station now, and that includes looking at how we can improve access to early legal advice. So I've talked a little bit about, technology and what it is that we are hoping that it will do to improve the service. And what I'd like to do is to break that down into two parts. To consider the sort of the digital technology that we are working on at the moment. Some of you, I'm sure, will be either involved with or be aware of the Common Platform Programme, which is the digital platform that we are developing for the end-to-end position of a case, and it's that digital sharing of case information to the relevant party at the right time. For example, for defence to be able to associate themselves with their case on the common platform and to be able to serve for themselves the initial details of the prosecution case. And also, because it's one of the big features that has consistently arisen, is how do you access the multimedia, so CCTV material at the same time, and that is absolutely something that we are also looking to have available. And fundamentally, this is about common access to case material by prosecution, defence and courts, and will include any reports that are uploaded that relate to vulnerable defendants and any adjustments that they may require for a hearing, be that a video hearing or in person in the courtroom. Video technology. I think this is fair to say that from our engagement so far, this is probably the area that causes most angst and raises most questions about how this could be used in the future. What we're looking for is to take advantage of the latest technology to improve the quality of the visual and audio experience, and also to use it so that we can improve operating processes that would wrap around that. It will be cloud-based. This actually allows us to remove the requirements of specialist fixed video equipment, which is what you will see at the moment, that it's either fixed in the courtroom or in a prison or indeed sort of in those police custody suites where they have live video link. So participants would be able to join via a web browser, which actually means that you would be able to use a laptop that you've bought off the high street rather than it being something that is high-tech and therefore very expensive. Another concern I know that has been expressed by the defence community. Some of the key features that we know that we will need to build into the service and that the technology will have to be able to provide are that participants can have their own private, offline if you will, away from the formal hearing conversations. You need to be able to test the equipment yourself so that you can check the settings for audio and for the visual, and we will also have easy access to a video hearings administrator should there be any queries or you require any support. I was going to change the heading of this to, so what have we been doing in all this time? But what have we been doing? So, as Kevin said, the video remand hearing service project is part of the wider court reform across crime, family and tribunals jurisdictions. We started in September last year, and we are aiming to complete the project in October 2020. Some of you will be aware, some of you won't. We are working closely with the Police and Home Office funded programme known as the Video Enabled Justice programme, which are based in the South East. In particular, we are looking, and I will talk about it a bit further in the presentation, but we are looking to test the sort of a prototype, proof of concept in Kent. And the working estimate is that there will be less than 10% of magistrates' court hearings that could be fully video in the future. The purpose of the project, and I'm sorry if I sound a bit like a broken record here, but it is to simplify and streamline outdated processes. We've had a tremendous amount of feedback from professional court users about processes that just simply do not work, and part of the design of the technological solutions is to see what we can do to automate or to improve those processes. We want the future service using technology to provide greater flexibility about how people can access the service, and we want to obviously use the latest video technology to help us do that. In doing that, we want to make sure that a user experience of a video hearing is much improved and enhanced from what it is currently. And I think really key as well is to introduce a consistent approach nationally, so that what we have is a set of standards, processes and procedures that, irrespective of what court you went to that was, sort of running that video hearing, then it would look and feel the same. So this next slide is quite busy. I won't talk through it on a line-by-line basis, but what I would say is that this diagram sets out our vision for the future video remand hearing service. It outlines the overarching service goal for each stage of the process. It's been informed by collaboration with professional users so far, looking at the current service and what it is that we need to improve upon, and what are the sort of the features that we need to make sure that we deliver in the future service. And we will be looking to refine this vision as we start our engagement with the defendant in the future. But if I just talk about the sort of the pre-charge bit, just by way of an example. So a person who's held at a police station, who's suspected of committing a crime, has access to the support they need and understands what is happening to them. So that is a goal. That's what we want to achieve at that stage. And what this should then result in, if we achieve that, then if the police identify the person's access needs and the information is shared at the right time with the right people, then we should reduce the delays and increase the likelihood of being able to, to meet their needs appropriately, irrespective of how it is that they are then going to progress through the justice system. And I think that the bottom line on that is that if a detained person is given the information and advice in a way that they can understand and trust, then they're more likely to accept that the process has been fair and to accept the end decision. So everything that we're doing around the pre-charge process then is to make sure that we actually meet that vision as we have sort of set out there. And we have similar then for the other stages through the process. I want to talk a little bit now about some of the detailed engagement and collaboration we've actually been doing over this last 12 months. For those of you who are involved, you will absolutely understand that it's a very complex and quite a diverse environment and landscape that that we're working in, and getting and engaging with professional users is not something that we can do really quickly, and hence why we're sort of 12 months in with our progress to date. We've run a number of cross-agency workshops looking at a variety of key themes that have emerged. Discovery for us is a process by which we ask questions of professional users about current experiences of the current process, and also want to understand what for professional users they would require, a wish list if you like, of the future service, and particularly to identify opportunities for improvement and where technology can deliver those process improvements. So to try and step away from quite manual and labour-intensive processes which are fraught with risk and error, and to move into something that therefore is a bit more streamlined, a bit more reliable, and that everybody can gain more confidence in as we move forward. And we particularly have wanted to understand throughout this sort of discovery phase, what the experience from a defendant's perspective might look like. And as I've already said to you, there's a bit more work to do on that. I talked about the work that we're doing with the Video Enabled Justice Programme and the fact that we are going to be doing some proof of concept testing in Kent. And essentially, proof of concept is a demonstration which aims to sort of confirm that what we are looking at designing and building is feasible, and that it's on the right track to deliver what it is that we require from our technology in the future. What it isn't is an early version of the end product. I think I should just expand on that a little bit, because otherwise I think it sounds like a bit of a contradiction of terms. But what it means is that when we do the proof of concept testing, which is of both the technology and of the processes that we need to have around that to deliver the service. If we found that it didn't work when we went back to our users and asked those questions, we would essentially throw it up and throw it away and start again. Obviously, I'm hoping that as a consequence of all of the engagement that we have been doing, that we won't be doing something quite so drastic, but that actually what we end up doing is saying, this definitely works. We thought this would work, but now that we've tested it, we don't like it. Actually, we see an opportunity here to say, rather than do that, do this. We think it would be better, or even, because obviously some of this is going to be new ground, we hadn't thought about this before, but now that we're seeing it in operation, we think that we've got this benefit that we can actually harness, that we didn't even know that we had when we first set out. So the starting point is in Kent. It will be in Medway Court, which is already set up with a remand hearing process. We're looking at improving the existing processes first, and also adding in those design features that we've already identified that are desirable, or essential even, in the future service. So for example, something as simple as saying, we need to make sure that we've got a standard courtroom etiquette guide. So what does that guide look like? What does the script look like? Who's doing what? What does a defendant guide or introduction to a video hearing look like? We know we need to have these things in the final service, but we've got an opportunity now to both improve a current process that's operating in Kent and to put it in place and to start getting some feedback about how that is working, hopefully improving the experience and tweaking it as we need to before we start to consider anything like rolling it out further. And just to finally add that there's going to be, so the Video Enabled Justice Programme has commissioned an independent evaluation of that proof of concept testing by the University of Sussex, and from a video remand hearing project, from an HMCTS reform perspective, we will be able to see sort of what that evaluation starts to draw, so that we can learn from that and inform that sort of that ongoing design of a future national service. Just to add that in Kent, it's not just these two programmes that are going to do this in isolation. We have established a local implementation team in Kent, which comprises representatives from across criminal justice agencies, including the legal aid agency, CPS, as well as courtroom staff and probation, and the judiciary and legal professionals who practice in the Kent area. It's very much focused, as I said, on sort of trialling operational process improvements, as well as supporting the proof of concept testing. And that proof of concept testing, as I say, it does include some of the early technological design that we're looking at doing. For those of you who've perhaps got a bit more involved with the Common Platform programme, then if I sort of said agile working, then that probably would make more sense. So it's that early state to sort of test it, see what we need to do to improve it, and then develop from that. I've sort of emphasised the point that we've been doing quite a lot of engagement and collaboration, and aside from the direct engagement and collaboration that we've been doing, we've also been paying attention to some of the reports that have obviously come up and the concerns expressed, including comments in the professional press. And what I've done on this slide is essentially summarised what the sort of the key themes are that have emerged from that that feedback. So around vulnerable defendants, around information requirements, what's going to be available to who, when, about unrepresented defendants, concerns and some scepticism, it has to be said, about the legal aid process in a remote setting, if you require wet signatures, and we are working closely with the legal aid agency on that to make sure that a future process will work with a future service which could be fully video, and also looking at legal representation. What does the process need to look like? How can we improve upon encouraging and facilitating early take-up of legal representation at the police station? Things like, concerns have been expressed about what I would describe as corridor conversations that can happen in the physical courtroom at the moment. These are, described variously as the requirements for defence and CPS to sort of have a quick chat away from the main hearing, or for the lawyer to be able to speak with their client, or probation to speak with the defendant. And alongside that, I think, is that, and for me, that's in two parts. So this is about saying what drives the need for those conversations, and what can we do in the future service to remove the need for many of those conversations. So, for example, a lot of those centre around, we haven't received the evidence, we haven't got the right information, we don't know if you're ready yet to go with this case. So what can we do using technology and the process up front to make sure that you don't have to have those conversations? Having said that, we are never going to remove the need to have some of those conversations away from the formal hearing. And absolutely, therefore, it is a key feature, a key requirement of the future service that we are able to accommodate that in a fully video setting. Other concerns that have been expressed are very much around about the impact of video, so about the behavioural impact either on how individuals act themselves, or how it is that an individual may perceive observing somebody through a sort of a video setting. What is the impact on outcomes? We know that there has been some limited and quite old research out there, and recognise that that is a concern that has been expressed, frankly, to us, and that we need to follow up on. And again, it links in with the information part about how much time. The reality check of it's very fast moving, and in a physical court there's a lot of moving parts going on to be able to manage that, to make sure that cases are being called on sort of quickly. But how much time is going to be available for the parties to a case to be able to consider the information provided and to prepare for it? And we've obviously got some work to do there as we go through the sort of the testing of what a process might look like, to understand what is the time the time lag, if you will, between defendant is charged to actually then being ready for the case to be called on and to be heard. What does that actually look like, and what does that mean for us when we start thinking about schedule and listing options? And what have we done so far to start addressing some of those concerns and that feedback that we've had? So, for example, last week we ran a national workshop looking at vulnerable defendants. How will we manage vulnerable defendants' needs? So we had representation from across the criminal justice system, and we also had a representative from NHS England, who is very much focused on and considering liaison and diversion services that would be available in that future service. Obviously, when I talk about this, it's not just limited to a video hearing setup. These things also will be taken and apply equally to all remand hearings, to think about what it is that how are we going to assess, who's going to assess, what are we going to identify, how are we going to report this, and how is that going to be presented. Being done initially by this workshop last week, the outputs from that are currently being pulled together to be able to take that back to get feedback from the judiciary. We are doing this initially through our judiciary engagement group, the magistrates engagement group in October. Undoubtedly, they will consider that process and what we are saying. We think, based on all of the feedback we've had so far, pull it apart, put it back together again, tell us to go and rethink, and we will do that. And through that process, we will come up with something, I am sure, that will be a robust and it will cover all of the requirements that we need to have in that future service. Other things that we have already started on, but again, that is still very much a work in progress, is to consider the processes that we would need to have in place at a police station to encourage and facilitate early legal representation. It is really important to us that, as in a physical court setting, that a defendant can easily access a legal representative if that's what they wish to have. It's not for us obviously to make those decisions, but we absolutely need to make sure that a defendant understands and is as informed about their options, and that it is easy and they trust the process by which they could instruct a legal representative. Again, work has started on and more work to do around looking at what the legal aid application process needs to look like in a fully video setting, so that that is efficient. We're working with Common Platform so that the features that we are identifying in the process, for them to understand what Common Platform design and build will need to look like to support the video hearing service. And obviously the whole thing around, commissioning user research, that's in, so with defendants, that's currently going through a sort of planning phase at the moment, as is considering what the evaluation requirements away from what the Video Enabled Justice Programme is doing to support and really to reassure professional users and defendant groups that, that actually we're not putting in a process that is worse than or the equivalent of a dreadful process, but is much improved and a viable alternative to appearing in a court in person. This next slide covers off, some of the more detailed engagement to date. I don't propose to go through that verbatim, but to say that yes, we have engaged across a range of groups and sessions, whether it's workshop or it's presenting or it's bilateral agency conversations and meetings that have been going on, and that will continue as we continue to design and develop the future service. And just to summarise, therefore where we're at, so the work today, we have got a first version of what an end-to-end service design, sort of might look like. So that's our straw man, if you will. And now where we're at, this work in progress that I've described, is to start and pull out aspects of that design, either because we need to get more detail around it, like the vulnerable defendant position, or because we should now start to test it and get the feedback and see actually, yes, that's now something that we agree should be in that future service. So I've said that we've got more more work planned in the future. So we have got some legal professional engagement workshops that are coming up, focused very primarily on video remand hearings. The workshops present an opportunity for practitioners to come in and to help shape sort of this service and to contribute to that sort of reformed vision of the future. And we're looking to make sure that that we cover off the. So I'll just show you where they're. So the ones that we've got planned so far in Nottingham, Sheffield, and Leeds in November. But the things that we're going to cover include, sort of the process to encourage defendants to request legal representation at the earliest opportunity, to look at the current process for the application of legal aid, and to explore, sort of, what the changes might need to be from the current process to enable fully video working, and to look at the outputs of the vulnerable defendant workshop to get more insight and information from defence practitioners. If you're interested in getting involved, and I hope that you are, then, as I say, those are the ones that are planned in at the moment, but obviously we will continue to look at and across, other parts of the country set up other workshops. Then please, sort of email Rosie Pugh in my team, and we will also advertise these workshops through email alerts. And if you know anybody else who may be interested, then, please do pass the details on. I hope that's given you enough of a sort of a flavour and insight into what we're doing in the video remand service project. And I think, in conclusion, what I would say to you is that we are really looking to develop a framework, a technological framework and a way of working framework for how we could operate a fully video service in the future. What it won't be is a mandated service. The judiciary absolutely will be the ones who will both oversee and decide whether or not a case is appropriate to be heard over a video link. And what we must do is we must make sure that the process and that we are designing and developing allows for that to be able to work in a fully video setting. Thank you all for your attention, and I'm going to have a drink of water while I then have a look at it, because I'm aware that there probably have been some questions coming up whilst I've been talking, and I'll hand over to Ed, who will hopefully give me a couple of minutes to have a drink of water before I then start answering the questions. Okay.
Thank you, Julie. Yes, please do take a sip. Well, to help you out, I will answer the first question. So, and I should say we've got about 100 people part of this webinar, so that's really good news, and thank you for joining again. I'm just going to answer the first question myself, not just to let Julie have a sip of water, but one of them is asked, can we access the slides after the event because the future vision slide was too small to read on screen? I'll answer that by saying yes. As I say, we're going to publish the presentations, and any questions we can't answer as part of this session we will publish. So we'll get those onto the HMCTS website as soon as we can, so you'll be able to see those. I know that, by the way, just to say, there have been a few sound problems and some problems with the slides, so I apologise for that, but as I said earlier, this is the first time we've done a webinar, and I hope you'll bear with us. So, Julie, on the basis you've now had a sip of water, I'm going to ask some questions that have been coming in. There have been a number of questions, which is great. And the first question is, how will the confidentiality of discussions between solicitors and clients be assured?
In a fully video, so I'm going to assume that this question relates to in a fully video setting.
Yeah.
For those of you who have been involved in the current process where it runs, I think what you'll be aware of is what happens is that the courtroom is emptied if it's during a hearing, so that the defendant can have a conversation with their lawyer, and that's probably not very satisfactory. And also there has to be some pre-booking if we're doing it via video link, so that so the defence professional can have access to a video point in a courtroom, and they can then, and the video room's got to be booked at the police station as well, and that's how it happens currently. In the future, and please bear with me the fact that this is not completely landed yet, but what we are looking at developing is that you can have, away from the formal hearing, a direct one-to-one consultation between defendant and defence representative, or defendant and probation, or whoever, and that will be through the technology that will be being applied, that will be confidential. It will be a channel that can only be accessed by those parties to that particular consultation. I'm afraid I'm not a very technical person, and I know that there's quite a lot of technical aspects wrapped around that, but in essence that's what will be able to happen. So A, it will be more accessible than what it currently is, and B, absolutely it will need to be, and we'll need to demonstrate that that is confidential between those two parties.
Thank you. Another question, if participants are using their own equipment, how do you ensure that they are located in a suitable place, i.e. not from a coffee shop or a pub?
Yeah, it's a good question, and I think that part of what we will be doing around that is working with our professional users. We will absolutely have to look at and consider what guidance that we need to, as part of that, processes and standards that we actually need to draw up and say, if you are a party to a hearing, this is what it is that you need to have in place by way of it being a suitable backdrop to engaging. And I think it's far too soon for us to actually say, and we have now defined exactly what it is. And I guess, because you're just asking me on the hoof here, it will include things like saying it is not suitable to do it in these locations, therefore.
Thank you. will it be necessary, or it will be necessary for the legal agency to abandon the need for a signature by the defendant on an application for a representation order if these are to be virtual consultations? Could this be borne in mind?
Absolutely, and I think that, and you will have gathered, and I don't know at what stage that particular question was posted, but you will know that the future workshops that we've got lined up in autumn, that is very definitely an area that we want to consider, look at. The legal aid agency will be involved in those workshops, so it is about working closely with the legal aid agency so that what we have is a process in place that works and will facilitate a fully video service.
Thank you. A further question about security concerns over the software and access to the system. Anything you can reflect on that?
I mean, I know that from a common platform, and I know that the early work with the video hearings project, so that's the project that is specifically looking at the video technology that the court service will look to have across jurisdictions, not just in the crime space, is to look at what's called, I think that's sort of like a two-step identification process. I'm not overly familiar with the detail on that. I know that there will be identification and security around that access. And again, this is something that, for me, it's not going to be dissimilar, I wouldn't expect, than what you have across the variety of online channels that you might access now, whether it's shopping or other services online.
Thank you. Will the solicitor remain at the police station for that hearing, or will the solicitor have to attend court for such hearings?
So I think this is part of the service design to look at. I mean, for me, it's not about mandating where a solicitor needs to be. I think it's about making sure that the future service can facilitate all parties attending remotely. So that would include that a defence representative could be in an alternative location from either a courtroom or from where the defendant is in a police station. Whether or not that then happens, I think will be dependent on a number of other aspects, but we definitely want to build a service that will allow that to happen.
Okay, thank you. Another question, is the estimation of less than 10% of current magistrate court hearings being fully video just relating to hearings currently in court, or does it include single justice procedure hearings not currently dealt with in open court?
It's first hearings of those individuals who have been refused police bail, and that's based on the numbers that we had from I think it was from 2015. And all we're talking about here is that's the total number of hearings. What we're not saying is that it will be all of those hearings. We're saying that's the kind of the maximum. It won't be all of those hearings for a number of different reasons. So it won't include SJP. It's purely about where a defendant has been refused police bail.
Thank you. Someone has asked whether we'll put the dates of the workshops up again, please, and we'll certainly do that. I should also say that this overall webinar and presentations has been recorded, so that the recording of that will be made available. So please be reassured that anything you've missed or that you feel you want to go over again, it will be available. So please be reassured on that. A question for video hearings, when a bench is made of 3 magistrates, will they be co-located with a legal advisor physically present?
Our expectation is yes, although occasionally it might be that a legal advisor joins in from an alternative location for good reasons. We'd want to build the flexibility in, but our working assumption is that it would be a bench co-located with a legal advisor.
Thank you. And then I've only got time for one more question, which perhaps I can ask the question here. Sorry, that there are many other questions, but we will, as I said before, we will make sure that they are answered in writing and made available. What about unrepresented defendants? Will video remand hearings be suitable for unrepresented defendants?
I mean, unrepresented defendants are clearly of concern to a number of professional users and, also the judiciary. The reason why we're very keen to make sure that we design a process that can be trusted and is straightforward to encourage defendants at the police station to access legal representation. Obviously, what we can't do is insist that a defendant has legal representation. But we would need to make sure that we do everything so that they can have legal representation, including during a hearing if they start off. Ultimately, it's for the judiciary to decide whether or not that case is suited for a video hearing. So even if an unrepresented defendant expressed a desire for their case to be heard over a video link, the judiciary, the bench or the judge may decide that actually no, they want that individual to come before the court. And I think it's more, I couldn't be more prescriptive than that, because I think it will always depend on the individual case in that sense. But we absolutely do want to design a service where somebody who chooses to be unrepresented and that their case is suited and the judiciary believes that the case is suited to be heard over video hearing, that it can be.
Thank you, Julie. That's all the time for questions we have, unfortunately. There are some other questions that have been entered, and I can only repeat that they will be answered in writing, and we'll make sure that they are available alongside a recording of this event on the HMCTS website. And we'll obviously, we're going to email the link to all those of you who have participated today. So apologies for those who have asked questions and they haven't been answered. I'd also like to say to those participants, all participants, that you can look at the HMCTS homepage to find wider information about the reform programme, including a link to the latest issue of the reform update, which gives a consolidated overview of all projects within the reform programme, as well as the overall rationale of the programme itself. It's also, if I can emphasise the importance of us getting feedback on today's webinar. As I said earlier, this is the first time we've used a webinar. We want to engage as many people as possible, so we're keen to get your feedback about the time, about the technology, about the way that we are interacting, and we will be sending out a questionnaire, so please fill that in. It's important for us to get that feedback from you all. I want to thank Kevin for introducing today's event. I also want to thank Julie for her presentation and for her diligent answering of the questions. But most of all, I want to thank all of those who've joined us today on the webinar. It's been, I hope, useful for you to hear and engage on this important issue. I can repeat that there will be further events. Please go onto the website, and I think that we'll be putting up a slide of some further activities that HMCTS is putting on, with some further events that are coming up on civil reform, on family reform and on crime reform, and there are a mixture of face-to-face events and online webinars. We obviously want to engage as widely as possible, and so please do participate. So thank you again, thanks for listening, and have a nice rest of the day.